We're back continuing our discussion of H524, which deals with sealing. And we have with us the governor's legal counsel, Jay Johnson. Jay, thank you so much for joining us.
Thank you, Senator Sears. Thank you for having me. And good morning, committee members. Thank you for having me. I did ask, so thank you for your patience and your tolerance. So for the record, I'm Jay Pershing Johnson, Governor Scott's legal counsel. I do appreciate the opportunity to testify on sealing criminal history records. And I hope you don't mind if I read my remarks, which really just helps me keep my thoughts organized, but no, please feel free to interrupt.
Go ahead.
So as you know, we've grappled with expungement for years. I think this is the sixth bill in going on 6 years seeking to expand expungements and sealing. Last summer, when the concept of sealing only was introduced, we were optimistic, as I think Commissioner Sherling indicated, that this could expand our policy options and areas of agreement. As he noted, universal sealing gives us the opportunity to balance the benefits of sealing records, which would be relief for offenders from collateral consequences, and in Vermont there are many, and as a means to reducing barriers to employment, housing, and education. This balance, of course, needs to be with the health and safety of our communities. So I think a properly crafted or a well-crafted sealing law could balance those considerations. I'm disappointed the House version simply creates a sort of expungement light in order to make a number of nonviolent felony crimes available for sealing and expungement. I also understand that may be entirely the point, but I cannot support the bill as written. I appreciate Senator Sears' observation made earlier that this gives us another chance to sort of think about and talk about the system and what it should look like. So our primary objections are threefold. First, as Commissioner Sherling made clear, criminal justice agencies need access to those records to be able to do the jobs we expect them to do. As an aside, and I mean no disrespect to Senator Baruth, but the temptation to access suggests an inherent distrust or abuse of power on the part of law enforcement. As Mike noted, they have a lot of access now, and the abuse of power in those situations is disciplined. I think the concern is misplaced. Commissioner Sherling testified to the need for informed response. I know there was a lot of debate about this in the House, but I think the legislature expects and codified an informed response by law enforcement in the use of force bill. So to Mike's point, I think that, we are expecting a lot from law enforcement while at the same time tying their hands with this sort of overriding distrust of law enforcement, which again, I think is misplaced. Second, our second objection would be, as the recent conversations regarding S30 and S4 demonstrate, we need a NIC system with integrity, and that means criminal records need to exist. This would be to keep guns out of the hands of people who should not have them. This is true as well for background checks required by law and rule. Our background check laws are only as good as the data that's available to check. Finally, this bill, and I think this is an opportunity that's presented with sealing, does nothing to simplify or streamline the process for those who may be eligible for expungements or sealing now. So the chair I read when Vermont Digger covered this story, the chair of the House Judiciary cited two testimony from a representative from the Brennan Center in support of that committee's version of H534. I watched that testimony, and that representative pointed to a New York Senate bill, which the Brennan Center supports, and it's a clean slate bill, which seals all crimes, but has exceptions, which include access for criminal justice agencies access for NIC system purposes and access for background checks required by law, and other exceptions for circumstances noted by Commissioner Sherling, which include various benefits for defendants themselves. I'm not saying this is the model for Vermont, but it gives us a different way to think about the potential of sealing. I would like to note again, as I have, I think, in the summer when I testified before the Joint Justice Oversight Committee, that Vermont's expungement laws are already quite robust. I would argue, when I look at other laws that are, often pointed to by advocates as models, that ours are really, in many cases, as broad or broader than most states. I think, despite the rhetoric of advocates. And I understand that there are some very unfortunate personal stories, but this is a very broad policy, which has a lot of broad policy implications, and I think we need to keep that in mind. I have shared an inventory of the expungement and sealing laws in the past. There are at least 5 expungement and sealing laws for juvenile offenses alone. And these include virtually automatic expungements for successful completion of diversion and virtually automatic expungement of qualifying crimes, which includes all nonviolent misdemeanors. It includes successful, and actually they complete the terms of the conviction. As Senator Sears noted, they also include sealing the records of adjudicated delinquents for all crimes other than the Big 12. And they include the sealing of records of all youthful offenders upon successful completion of the probation term for any crime. There are an additional 8 expungement laws and sealing laws for adults, including virtually automatic expungements for successful completion of adult diversion and successful completion of the terms of probation for deferred sentence. In the case of deferred sentences, this is all crimes other than listed crimes and 2 specific sex crimes against children. All misdemeanor crimes other than listed misdemeanors are eligible for expungement, as are convictions for drug possession. So we also know from data and analysis of the Council of State Governments that the number of criminal cases filed in Vermont is fairly steady at about 15,000 cases per year. Of that number, roughly 78% are misdemeanors. So almost all misdemeanors are expungible now, other than violent misdemeanors, are expungible now. So that's 78% of cases brought in Vermont. Roughly 20% of misdemeanor cases and 10% of felonies result in dismissals and expungement through diversion. So that's happening now. We also know 99% of convictions are the result of plea agreements. All misdemeanor charges, and again, this is from the Council of State Governments, with convictions are convicted as misdemeanors, eligible for expungement, and approximately 40% of all felony charges are convicted as misdemeanors. So felony charges, which become misdemeanors, are eligible for expungement. We know from changes made in 2017 to the Uniform Law on Collateral Consequences that the courts are now required to advise offenders of the opportunity for expungement and sealing in pretrial proceedings, and again by DOC at release. So most criminal records are already expungible. All criminal charges which stay in family court, including charges of violent crimes committed by young adults, never even become criminal records. And yet the widely reiterated talking point these days has been that this is a workforce bill, freeing up the workforce, hardworking Vermonters who are convicted of crimes with records, long-standing records, no intervening crimes, no risk to the community. Most Vermonters who have committed crimes are eligible for expungement now, but this is not happening. We know there are thousands of expungements every year, but there is, seems to me, a vast pool of Vermonters with criminal records eligible expungements who are not seeking them now. And again, as I noted before, sealing may give us the opportunity to streamline and simplify our expungement and sealing laws in a way that may actually produce the kinds of numbers that we would want to see for under existing law. So, I mean, the expansion to felonies is something, but I would not characterize H534 as a jobs bill. And by the way, we actually have a workforce bill, housing bill, and an economic development bill struggling to get their way across the finish line in the legislature. So as far as social determinants of success would go, you would think that this might also be a priority. So again, we believe there's a path forward on universal sealing, which yields the policy outcomes of reduced collateral consequences, better jobs, and more opportunity for housing and education, but not at the expense of the public safety of Vermonters. So that's my testimony for today.
Mr. Chair,
Yes, Senator Baruch.
if I might, Jay, you talked about the background check system, and I'm intrigued to have you just unpack that a little more. So my understanding was that the 2015 law we passed makes sure that we pass our information from Vermont to the NICS database. So then the people who have been reported, that there would be a number of years intervening, and then they might in the future ask for expungement or come under sealing. So their name would still be in the next NICS database, right?
To my knowledge, once a record is expunged, it comes out.
Yeah.
And again, this might be a question for Jeff Wallen.
Well, then I guess my question would be the sorts of crimes that we've not allowed to be sealed or expunged seem to me to be the ones that stop your access to a firearm. That is domestic violence crimes, violent assaults, etc. The things that are eligible for expungement, are there examples there of things that would stop you from getting a gun that we're allowing to be sealed?
Well, I actually had that question because anecdotally, there's a little bump around hunting season for requests for expungement. Again, that's just anecdotal and there's no real hard data to support that. And I asked that question, how is it that those people are looking to get their guns back if those crimes are not eligible? And the answer was there are lots of ways to get your record sealed or expunged, as I noted. So you can, there are a number of ways that your record goes away after diversion, and diversion has been expanded over time. There are deferred sentences where once you successfully complete, you can get your record expunged. There are all offenses that go through the family court system. And again, that's juvenile and youthful offender. So there are a number of cases which make their way through the system that could be violent crimes that ultimately, through other means, through our expungement laws as drafted, could be expunged or sealed.
Understood. So that's something I thank you for that, and I'll look at that as we go forward to try to eliminate that if it is the case that there might be someone who shouldn't have a gun who through sealing might be able to get a gun. The other question I had was, you said that now law enforcement has access to a lot of information, a lot of cases, but I'm still thinking about things that are called expungement now, and where the records are destroyed or where the records are reduced. Law enforcement has zero access to those cases because they're destroyed.
Yes.
So that's what I'm thinking. If this bill didn't pass, we would have a situation still where expungement allowed law enforcement zero access. So I think it's not accurate to say that now they have a lot of access and they should retain it. Now they have zero access to expunged cases. And what we're talking about under a universal sealing idea is that law enforcement would again have access to those sorts of cases. So I don't think it's beyond the pale to talk about keeping that access very, very limited because now they have none.
But H534 takes that
Yeah.
access away.
Well, understood. So, but just to, you were calling it a path forward.
But it expands the universe.
Yes, it does.
And it shortens the time period, and
Yep.
then it removes that access.
Right. I'm just.
So it would have
trying to-
greater impact on the
Yeah.
access of law enforcement to records.
Yeah. I just want to highlight that what we're doing is moving away from a system where we promised the people who were expunged that there would be zero access by anybody to their records, that it wouldn't
Sure.
exist. So if we are thinking already about some acceptable compromise, personally, I think that compromise should take, well note of the fact that now expungement allows zero access. So if you get something, that's more than you have now.
I appreciate that.
I really, your testimony refers to a number of bills already passed, and it leads to me to a question maybe you and Michelle can work on is what is the inventory of current law as far as what's sealed, what's expunged, and I certainly don't want to, we've already got a number of laws on the books, and we should be looking at what's lacking, not what we should add, in my opinion. Well, excuse me, we should only add what's lacking. So it would be interesting at least to have an inventory of current law, and you've cited a number of cases, so perhaps you could work
I'm
with
happy to
Michelle
share
on
that.
that.
Yeah, I'm happy to share that with
That
Michelle.
would be helpful. And I do want to, during the break, I was thinking more and more about my example of saying over 400 kids I dealt with. I never heard a problem of access to those juvenile records. The only one that I ever did have, and I've been thinking about it, was a kid who had committed a crime, was found guilty of delinquency for a crime that landed him somehow on the abuse registry of DCF. And when I tried to hire him 10 years after he had been in the program, it was declined because of what he had done earlier. And then I went through that and found out, and we did work out something for him. But it was it wasn't the juvenile record, it was the abuse registry of DCF that was still in existence. So I just, yeah. And that's true because now you can appeal those prior old things. And at the time he couldn't, but it was interesting that was what came back.
Mhm.
Was not what was in his juvenile record.
Right.
Senator Sears, can I ask a question?
Sure.
Jay, the first expungement bill passed this body over 10 years ago now. And since that time, as of about 2 months ago, there have been over 24,000 expungements. I've heard a lot of speculation, but is there any evidence out there that police were somehow inhibited and left in a situation where they were unable to fully discharge their functions?
I get, you would have to ask Commissioner Sherling. 24,000 expungements, I think, given the pool of people over the last 10 years with the rate of 15,000 charges a year, seems to me very small. And it will certainly depend on the crimes. So, I mean, you would have to ask law enforcement, but I couldn't answer your question.
Okay.
I mean, I also know that you passed the law maybe 10 years ago, but in 5 years ago, we changed the waiting period from 10 years to 5 years. So you couldn't even get a misdemeanor expunged before 2017 before 10 years. Now you can get it expunged after 5 years. And this bill, I think, seeks to shorten that period to 3 years. Sealing certainly gives you more options, as Commissioner Sherling noted, with respect to time period. But, you know, I mean, there were different laws in place for 5 years preceding 2017 that might not have yielded many expungements at all.
Well, the question still stands. We do have a track record of expungements, and I'd like to know not just what the speculation is, but what the factual reality is out there. I haven't heard that. I didn't think to ask you, Commissioner Sherman.
I think I would ask, I mean, you might want to ask the courts about the kinds of crimes. I have asked the VCIC, and it's difficult for them. They basically say that, you know, you should head back to the courts, which is sort of the source. And with respect to impact on law enforcement, I would have to defer to representatives from law enforcement and subject matter experts.
Well, I've got on a list for next time is Jeff Wallen. We should certainly hear from him to better understand the impact on the NICS system and others' criminal record histories. Other questions for Jay? Jay, thanks so much for being here. Appreciate your testimony.
Thank you. Yeah, thank you so much for having me.
Anytime. Judge Zone, your name has come up several times. Oh, I'm sorry. Gwen Zakoff from BLTC is the next witness. I'm sorry, Judge. I jumped the gun.
Hello, committee.
Good morning.
Good morning. This is Gwen Zakoff from the Vermont League of Cities and Towns. I am going to be speaking to a discrete section of the bill. It is section 7 of the bill, which deals with expungement of municipal violation records. What this really is getting to is violations of civil ordinances, and the proposal before House Judiciary and now you came from the city of Burlington. I'm not sure if you're going to be hearing from the city attorneys there, but essentially this language is needed to fill in sort of a gap that's in current law, which currently there is no means or mechanism in law to expunge records for civil ordinance violations. And this new language would now allow for those records to be expunged. VLCT supports this language. There needs to be a mechanism and a means to expunge some of these records, as you've heard from prior testimony, just in a different means, go back decades. These civil violations at the local level are pretty minor, I guess you could say. Some of the violations we're speaking towards are things like trespass or disorderly conduct, graffiti, and other relatively mundane things like civil violations of solid waste ordinances or animal control or noise and those sorts of things. There is a carve out here for zoning violations that would not be included in the expungement. We also support this provision because violations of zoning bylaws are very different from those that go to the Judicial Bureau and are sort of one and done violations of a person. The bylaw violations related to zoning generally run with the land and span many years. And so it wouldn't make sense to extend expungement to those, but it does make sense to expand it to Title 24 2291 ordinance violations. And that is my testimony, and happy to answer any questions.
I'm smiling because I remember hiring somebody one time and the background check came back with leash law violations, and that was the record. But actually DCF questioned those but we still hired the guy anyway, even though he was a leash law violator.
Was
any
it
questions
a leash law violation for a dog, or that he was supposed to be on a leash?
Well, that's an old story, but yeah.
Okay.
He was supposed to, no, it was a dog.
Yeah. Okay.
So is that an automatic expungement? Or would one have to ask? You know?
I believe as written, it's automatic.
Okay, thank you. 'Cause I can imagine all the people who may not remember they had this
Yeah.
violation, so. All right, great. Any other questions for Gwen? Gwen, thank you very much for the testimony.
Thank you.
I don't know that we need to hear from the city attorney in Burlington on it. It sounds like general support for this.
Great. Thank you.
Thank you. Judge Zone, welcome.
Good morning. Thank you. Good morning, Tom Zone, Chief Superior Judge. And I can't help but comment, that's probably one of the very few times that Ms. Zakoff, if she was going alphabetically, has not been last. If it's okay, I'll actually address that section 7 first because she was just talking about it. We have no issue with that. It is automatic. The only suggestion that I would make is on page 25 of the bill, on line 3, it says, upon an entry of expunged, the case will be accessible only by the clerk of the court for the Judicial Bureau or the clerk's designee. I've chatted with the court operations side. That's a little too limited for practical purposes, and I would suggest that in addition to the clerk of the court, it be the director of trial court operations added in there. So it would say director of trial court operations, comma, clerk of the court for the Judicial Bureau, or the director or clerk's designee. That way you have the ability to make sure they can respond immediately if someone's away or things like that.
Okay.
As far
That
as
sounds pretty reasonable.
as far as what I'll call the big bill, sealing in the criminal courts, we do support the one track going towards sealing. That is, of course, a policy decision for the legislature. It will streamline and make more efficient the operations of the court to address that. But nonetheless, we recognize that's a policy decision which direction the court wants to go in. I'm sorry, the legislature wants to go in. Similarly, when you look at qualifying crimes, that's a policy decision. When you look at the use or access, that's also a policy decision. And I will touch on something Senator Sears said and asked about in a few moments about the access. Before that, on page 15, the bill talks about a stipulated sealing if the petitioner and respondent stipulate. And in that section, it says basically that if they stipulate, the court shall grant it. If you relate back to the definition section, the respondent is the state's attorney or the attorney general. However, the section on stipulations does not define that the state's attorney or attorney general who prosecuted the case has to stipulate to it. And so there's a question. And what happens if it's a crime prosecuted by the state's attorney, but we get a petition filed by the attorney general and the petitioner, and they both sign off on it? Is the court to grant that? Well, under the plain language, the answer would be yes. What, however, happens if that is filed and the state's attorney says, no, I don't agree to that. I was the prosecutor. And so I believe Mr. Meenan has submitted in his written memorandum language that addresses that particular issue. And for purposes of clarity, the court would support having it be very clear that unless there's an agreement by the prosecuting officer to have this other agency sign off on it, any stipulation would have to be signed off on by the agency that prosecuted it. The statute also goes on page 22, and it talks about a section on dismissed charges. And I think actually Senator Baruth yesterday may have asked a question about this, because it says the prosecution may object to the loss of access at 3 years by proving that the loss of access would pose a significant risk to public safety. This is not in connection with the earlier sealing requests if someone has a conviction. This is about dismissed charges, which will be an automatic after 3 years. The language is set forth uses the term prosecution. And again, this relates to my prior comment about, well, that term is actually undefined, but does it mean the state's attorney or the attorney general? Can the attorney general object if it's a state's attorney case that was dismissed. And so these are questions that the court has. But the other issue that arises here is it doesn't talk about the process. In other words, it says they can object if they prove something. Well, what's the burden of proof? Is it, well, maybe, probably, preponderance, clearly, clear and convincing? And so I would suggest that this would need to be addressed to make it clear that something has to be filed in writing in advance of that 3-year period that outlines specific facts that the loss of access would pose a significant risk to public safety. The court could then hold a hearing prior to the 3-year period, and the court could determine whether to extend that access. I could work with Mr. Meenan and the Defender General, whether it's Mr. Valerio or Mr. Paul, and come up with language. I don't think I'd have language today that I would be comfortable going forward on, but if this committee would find it helpful, I'm confident that the group of the three of us could come up with language that addresses that to make it clear as to what that process is. And I would note that we've done something like that in connection with probation and objections to extension. So I think that would be something that we could work on to address. The question that Senator Sears, you've had, if I've heard it correctly, you've talked about juvenile sealing, process there, and I think this morning with Commissioner Sherling, you talked about access. Well, the access is controlled under Title 33, Section 5119, F4. And it does provide the state the ability to come to the court to ask to see its sealed records. It says the state's interest in public safety would have to clearly outweigh the purposes of the juvenile sealing law and privacy rights, and the sealed record is necessary to accomplish the state's interests. And so there is a procedure that when you have a sealed record, the state can come to the court, ask the court to be able to review that, and the court can permit that. And the statute goes on to talk about how it is limited. So I point that out only because if you're considering the access issue, you may wish to consider, as I think Senator Sears, you've correctly pointed out, what we've been doing for a long time. And that may be something that if you feel that it works and it furthers the policy, then it may be something you would wish to incorporate into this.
Well, to be honest with you, that's why I've raised it, because, you know, I've had all kinds of delinquencies over the years that I've dealt with, and I've never had a complaint from a former resident or current resident about access to those records. And many of those folks, as I pointed out earlier, are in their 50s and 60s. So
that, I don't have anything further today. Something tells me that the bill might look a little bit different going forward. I'm sure I may have comments at the time.
You know, obviously, we're going to take into consideration the testimony we get from a variety of folks, including the governor's office and the Council of State Governments. But I'm curious. I'm trying to understand what happened to the current law and the backlog. One of the reasons, let me rephrase this. God, how quickly.
Oh.
God, you know, we talked a lot about the backlog of expungements and going into all the records and so forth. And that was one of the reasons to go towards sealing, was that it's tremendously difficult to get all of the records. And sometimes you have one case expunged, but another one isn't. Can you talk a little bit about the advantages for the judiciary of a sealing versus expungement?
I would first say that it's important on that issue. I would want to have someone from the clerk side, for instance, the director of trial court operations, because they're the ones who do that specifically. As a judge, when we get a filing We review it, we sign it, but the real nuts and bolts is done by the clerks. And I don't have the requisite level of familiarity with specifically what happens and how they do the difference between expungement and sealing. Now, we've heard in the old paper days that we all know that they would have to take the file and literally there's things that you just get rid of. The file's gone. Technologically, since Odyssey has been in effect, I think there will be a difference. And that's a difference I would defer to our clerks on. And I could have one of them visit with the committee if that would be helpful.
That would be extremely helpful because I would like to understand what you go through under current law in order to expunge. And I understood there was a huge backlog in getting all those records unsealed. I know we put money into the 2022 budget to try to help the judiciary from ARPA funds in getting those records taken care of.
I can tell you, Senator, that the judiciary has been working at that. For one example, the Act 167, marijuana expungements. I know that they are something that the court is working on. That's also, we'll call it an automatic. In other words, it's no filing necessary. That falls on the courts. And so we've been working on that. And on the other expungements, I know that we have individuals who are focused on trying to make sure that they are done efficiently and timely. And I can get this, if you would like, again, I can get, whether it's Lori Canty or someone else from the Court of Administration.
If you could just give some names to Peggy and we'll try to get somebody in next week.
I will do
Court
that.
Administrator's office or the Director of Trial Court Operations.
I think Lori Canty, who's the Director of Trial Court Operations, let me visit with her. She would know the best person, and something tells me it might even be her.
If you could work with Peggy on that, we can hear from somebody next week on this. Also, Jeff Wallen from DPS.
I will take care of that.
Right. Questions for Judge Zone?
Yeah.
Judge? Yes, who was that? I guess
No, I
not.
just said thank.
Thank you so much
Thank
for your
you.
testimony. Very helpful.
We don't have
Our next witness is Josh Rutherford, the Director of Classification and Family Designation, Facility Designation, not family. Sorry, Josh.
That's all good. I thought you were adding to my duties, sir.
Well, no, I was reading without my glasses on.
For the record, oh, sorry, sir.
Yeah, go ahead, Josh, please.
For the record, Joshua Rutherford, Director of Classification and Facility Designation for the Department of Corrections. First of all, the department understands the goals of this bill. We're broadly supportive of those. We want to see people successfully re-engaging in society, re-entering, re-engaging, moving past a criminal conviction. Things like barriers to employment, housing, licensing, those are things we're acutely aware of. I remember conducting mock interviews in Northern State as part of the workforce development track that they have up there. And there's a whole piece about how to explain a criminal conviction in a job interview. So to the extent that those things are no longer relevant and we're able to remove some of those barriers, that would be helpful for the population. In fact, one of the side effects of the current worker shortage we're seeing is more opportunities for those with criminal justice involvement, either current or past. There is in the bill a carve out around DOC risk assessments. That is important to us. We use a number of formal risk assessment tools. We pivoted over some years toward more evidence-based tools and toward using that to guide more about our supervision. To guide what treatment and programming we provide for people, what level of supervision we provide. I'm sure the committee has heard in the past, concerns about over supervision, about the fact that if we have someone who's low risk and we're supervising them at too high a level or intervening too much, that can be harmful. So we really try and hit that right level where our supervision matches their risk. And for that, it's important that those tools be as accurate as possible. And so when there's information that we can no longer access, that inevitably makes those tools less reliable. I caught some of the testimony this morning, and you're talking about some very, very old convictions. You know, somebody 50 years ago, obviously that loses value. But as the state works to shorten timeframes and expand the crimes available, that information does become more informative to us. So the timeframes that are in the bill are a compromise that we can support. It allows for the sealing, but does give us that access for a period of time after. We do have one significant concern about the bill. In our reading, and we had counsel look at it this morning, this would allow for the sealing of crimes where an individual is still under our supervision for something else, or in fact, where they're still incarcerated. So we could have somebody max out a sealable crime and literally commit a new crime the next day, and then remain in our custody. And after the appropriate time frame has elapsed, have that sealed, even though they're still under supervision or in fact still in custody. That can be problematic for a couple of reasons. From a practical matter, those records are intertwined. We supervise people, not charges. So if we've worked with somebody and they came right back into our custody, those records are intertwined in our case notes, in our assessments. Disentangling those as a practical matter can be very difficult. We actually had a case where an individual who's serving on 3 Big 12 offenses was able to get some older convictions expunged. He'd been incarcerated and hadn't committed new crimes. So now we're going through 20 or 30 years of records trying to sort out the crimes that legally no longer exist, but are referenced throughout their history. It also creates an inaccurate picture of an individual. For most folks with more serious convictions, an aggravated assault, a murder, things like that, that's not the first offense. And so, you know, in the case that I referenced, now those 3 Big 12 offenses sort of appear on the record out of nowhere with no precursor. And in looking at the individual, there are precursors. There was criminal behavior before that sort of culminated in this. And our concern is that the way this bill is written would allow for that to happen more frequently. In the original House version, there was a piece that didn't allow sealing while somebody was still under our supervision. That piece has been removed. Obviously, we'd support adding that language back in, although clearly the House might not. We did think of a possible compromise solution. If something were to be added to the effects section, and as full disclosure, I am not a lawyer, so I don't know that I can speak to the exact language that would accomplish this, but language that at the time of sealing, if they're still under our custody and supervision, that we could continue to use and access records that we have internally for our purpose, but the public-facing piece would go away. So things could be sealed. What's public from our end is current charges, but we could still have record and rely upon those past charges they were completing that current sentence.
Yeah, I'm having a hard time understanding how this could be. I didn't think you could get a record expunged while you were in the custody of the department. I can see where you could get a record expunged that was 30 years old, and then you go out and commit a new crime. I can understand that, but it's
right. So this particular expungement appears to have been a one-off, an error, where somebody didn't catch that the person was still incarcerated. However, the way the sealing bill is written, it appears that could then become the norm, that there's nothing in the bill that would preclude somebody who's serving a sentence, even an incarcerated sentence, from having a prior crime excluded, sealed, even if that, like I said, they maxed it out and literally committed a new offense the following day.
All right. Well, we'll certainly. I get it again. I need to understand how that could happen, because I thought it was in the law, current law.
I think it is in the expungement. And like I said, that singular case appears to have been an error, but it did highlight the types of challenges that we're going to have if this current bill were to pass.
Well, I think we can see how other states have dealt with it through David Diamora and see where there is value to that and how we deal with it. But it certainly was never my intent to allow somebody to get a record expunged while they're incarcerated.
Thank you. We would appreciate that, and that's certainly our concern around the bill, is that we wouldn't be stealing the records in those circumstances.
Can I ask how long? I realize they've shortened the time frames, but you want the information for risk assessment, and the House put in a section that allowed that.
Mm-hmm.
So take MT, who's a woman who's I won't take her. Take somebody who committed a crime 30 years ago. What value was that in your risk assessment?
No, well, I don't believe the current the language in there would give us access to that. It's a shorter time period than that, and the longer we are from a crime, the less value that has. So in your 30-year reference, I don't think that's going to have an awful lot of value. But again, the state continues to shorten the time frames and expand the crimes. And while those are good goals, that information does become more informative in looking at risk as that happens.
Okay, well, other questions for Josh? Josh, thank you very much. We may need you back on this change, but so stay tuned.
Thank you very much, sir, and glad to come back if needed.
Good. Well, Peggy and committee, I think, we've heard a lot of testimony about the bill. Next week, I'd like to hear from Jeff Wallen, if he's available, David Diamora, and whomever is the director of trial court operations or somebody that they recommend to talk about the current state of affairs. And also, Michelle, if you could put together, along with Jay Johnson, some kind of a inventory of what we have now and how this bill might affect what we have now. And also, if we could hear from John Brown, the commissioner at DCF, on how the sealing works with and what access there is to sealed records and what access there is to juvenile records currently. So they're not sealed until a certain point. And once they're sealed, what is the access to those records? Who has access? How is that access handled? And better understand that juvenile system sealing. And also on youthful offenders. I don't believe there's sealing on the deferreds. Am I correct, Michelle?
It's expungement.
It's expungement on deferreds, and that doesn't change in this bill?
Correct.
Okay, well, that's one good thing. I support that. But understanding how that all works. Are there other things that people would really like to know about this?
Yes.
Senator Baruth.
Yeah, if we could get
some
information on that data being pulled from the NICS database, and which the overlap between eligible offenses, and then how many of those would get pulled from the background check database, because if we're inadvertently allowing people that have been determined not to be able to get guns to get them through expungement, then that would change my view on the list of qualified crimes. Does that make sense, Michelle? Okay.
Anything else that people would like to hear next week? Senator Nitka.
I just want to ask Michelle. Michelle, were you able to listen to Judge Zone's suggestions?
I did. The one that was, I was familiar with his what he raised on the issue about whether or not it's the state's attorney or the attorney general who can stipulate. That was an issue that was discussed in the House, and the House looked at, there was differing opinions between the attorney general's office and the state's attorneys, and they considered limiting it to the way that Judge Zone suggested in accordance with what Evan was suggesting, but they decided to go with the Attorney General's office, legal aid, and Defender General's position, which is the language that you have in there. So if you decide to go the other direction, I can resurrect that language. And then the other issue I heard from Judge Zone was that he was looking to perhaps work with state's attorneys and Defender General's office on just refining a little bit the language about the when a case is dismissed. And so I'll look for something from him and make sure that y'all get that for consideration.
Right. I do believe that we had a discussion during our debate on S7. Was it last year? And about the issue of the state's attorney, the attorney general, and who gets to do what. And I brought up, they were actually, I believe at that time, they were holding one of those events where they expunge records, and both the state's attorney and the attorney general were there. And if people were from another county, the attorney general was able to work with the expungement, but I think they had to notify the state's attorney in the other counties. It's already working, I think. That's what I was that roundabout way of saying what's in that bill is already working, I think.
I do think I remember that Charity Clark from the Attorney General's office and Marie had testified, I think, about those expungement clinics, giving that as an example in the House. So if you wind up having them back, they might be able to share some of that experience with you.
So it also might occur outside of those massive expungement clinics. It could just happen with regard to, two private people who know each other, and one had a conviction on their record and they both agree, okay, it's over. Let's try and get this expunged. So I think having the state attorney or whoever the prosecutor was just sign off on that also, as Judge Zone suggests, would be a good idea. So anyway, well, that's on page 15, number 3.
Okay. All right. Anything else? I think we're ready to go offline.